Day 20-20645, U.S. versus Hamilton. Ms. Greer?
Good morning, and may it please the court. We've raised a lot of challenges to the conviction and sentence in this appeal. And this morning, the court has a great deal of briefing on these issues. This morning, I'd like to focus on two issues that I believe cut across large swaths of the appeal, and for which the government has provided no answer. First, its failure to prove a lack of medical necessity with expert testimony. And second, its impermissible extrapolation from the claims involving two patients for whom fraud was found to thousands of claims for which it has offered no proof whatsoever of any fraud, again without an expert and without any evidentiary foundation.
So the second argument, are you accepting that as to Martin and Miller, it was sufficient, but they had to prove others? Or what's the second point you're going to make?
We are not, Your Honor, but I'm going to leave that to the briefs because there's a lot of back and forth, and we only have a short period of time.
That's fine. Good for you.
I think these are the two principles of law that would be of most interest to the court that permeate multiple factions, not just the conviction, but also the sentence. So that's why I thought it best to focus on these, if I may.
Yes.
Okay. First, I'll address the medical necessity point. In rereading the briefs to prepare for argument, I realized that I was less than precise with the terminology. We are arguing that there should have been medical necessity expert testimony, but that's, on Medicare parlance, that's done on two levels. First, there is the medical necessity documentation expert. That's the Lori McMillan, the government's contractor who testified at trial. They did not designate her as an expert, and they did not give her claim files to review. She testified that she could have reviewed the claim files for sufficient documentation, but she was not a physician.
She did testify to definitions of homebound, and it looked like that was unobjected to, largely.
She did, and homebound is a medical and legal standard.
But if, as a lay witness, if you thought she was testifying to something that required expert opinion, the appropriate way to get that up would be to object to her testimony, right?
Right, and again, we're not objecting to that part of her testimony. We're objecting to what she didn't testify to, what she wasn't asked to testify to, which was a review of the medical files. These medical files were done for each patient. We introduced several of the files at trial for the three substantive count plaintiffs. As the court will recall, one of them was not, Dr. Hamilton was acquitted on one of the patients. But as to the other two, Bernard Miller and Keisha Martin, we did introduce those voluminous files to show that there was a lot of documentation of medical necessity.
So the error here is, can you point to a Fifth Circuit or circuit case that has ever reversed on insufficiency for lack of an expert? A healthcare fraud case where the circuit court has said, without an expert, this is insufficient. Is that the proposition you're offering, or do you have a variation?
Two levels, Your Honor. One is, that's the first level. There's no expert as to documented medical necessity. But if you get past documented medical necessity, and you find that it's there, then the next level is to prove that there was actual lack of medical necessity, and only a doctor can make that determination.
And that's the question I'm asking you. Can you point me to a circuit case that has said only a doctor can do it? I know our cases have contemplated there may be a case, but can you think of any circuit case that is reversed on insufficiency because the government didn't offer an expert to say this wasn't a medical necessity?
I cannot. I believe this is an issue of first impression.
Okay.
Certainly the opinions that the government has put forward do not foreclose that possibility.
That's true.
And they're very clear about where the dividing line is. The dividing line is when there's ample proof that a lay juror could understand as defraud, things like concealment, things for like billing for services and testing that isn't done. Things like
the government's response in their brief is, well, you heard from the patients themselves, like Martin and Miller, and then you heard from other employees, and you heard from co-conspirator Flips. They all said these people could go in and out of their houses. Now, it's really debatable. Her story's plausible. She got on the stand, the only medical professional the jury heard, and she defended her medical judgment. But why doesn't that just make it a he said, she said situation?
Because lay jurors and lay witnesses are not competent to controvert.
But see, that's where I thought, I'm thinking there's no case law, but push back. If they weren't competent to make those statements, isn't the proper objection to their testimony rather than a rule that the government has to offer an expert? No?
No, Your Honor.
Okay.
I think it's a sufficiency of the evidence, plain and simple. They had to come forward to prove beyond a reasonable doubt that Dr. Hamilton lacked medical necessity as to her decisions. If you read the indictment, if you look at how the trial played out, it's all about, did she certify people who shouldn't have been certified? That goes directly to her medical judgment. And that is why this is an issue. And again, there isn't a case yet, but this could be the case. And
Keep going.
hopefully
I've asked
should
a
be
lot
the
of
case.
questions.
Medicare,
Why isn't that Congress's call?
well, Congress
I
is
mean, there are statutes, Texas medical malpractice laws, among other things, where there are specific requirements about the kinds of expert witnesses you need. Indeed, I think there are like threshold filing conditions in terms of that kind of expert testimony. You're not pointing at any statutory text here, are you?
I'm not, and Congress could make the call, but they don't need to because we have Federal Rule of Evidence 702, and that says that when there are experiences beyond what a layperson can know based on what is more technical than a medical doctor's judgment, diagnosis, and certification of what is needed for this patient.
When did you first make any variation of this argument to Judge Ellison?
I believe it was in the judgment for acquittal, the motion.
Well, I read the Rule 29, but there wasn't really any suggestion to him that I remember that the government had to have called an expert.
I don't think he made that specific objection, but he moved for acquittal and said that
No, he did. He
was
preserved the sufficiency.
sufficient,
Okay.
which is all that's needed to
Yeah.
preserve error on the sufficiency of the evidence. And there are, countless cases on the civil side where you don't have an expert, you needed an expert, your evidence is insufficient. This is no different. Medicare has made it clear that only a doctor can review a physician's certification, and that's because they need to engage on the same level. There's a case out of the 11th Circuit, which I focused on in preparing. It's the Mesquias case, which the Rule 28J letters were about, which just came out in the last week or so, cites this case. It's called United States versus Azeracare, and it's 938, 1278. Now, granted, it's a key TAM.
938 F third what?
1278, 11th Circuit, 2019. And it is a key TAM case, a False Claims Act case. So it has a tiny bit of a different standard, but it really deals with this issue as one of first impression in that context. And I found this case to be incredibly insightful in looking at the issue of whether a medical doctor is required. And one of the things that they talked about is that in that case, the government was saying, well, the decision about falsity ought to be determined from the medical records. It ought to be a documentation call. And the court said, no, that's not right. Because the clinical judgment, in that case it involved terminal illnesses and hospice certification.
This is the civil context, right?
Is a false claim, civil context. But I think it's analogous here.
True, but in the criminal world, you're going to have a whole separate set of concerns, right? An expert for the government can't testify as to state of mind, whether she had a fraudulent intent.
Right, but
it's going to be perilous for the government to put an expert on.
True, but the government could not challenge her certifications, which is where this would engage. This did not engage on concealment, signing blank documents, signing blank checks over to people, et cetera. This turned on whether her certifications were fraudulent or not, whether there was sufficient evidence. And they talk about opinion testimony can only be fraudulent, this is her judgment, can only be challenged if it's things like couldn't possibly be, like in the cases where the doctor is there 2 days a week and certifies hundreds of patients, those kinds of situations where it just can't be, or there's proof that she falsified. And there's none of that in this case. There's nothing to show that she...
Does it go to this issue that there were witnesses that said she never even asked, are you homebound?
Well, that's not her job. I mean, Medicare says don't even ask those questions. They say, here are the questions you ask. You look at the prognosis. You look at the diagnoses. You look at the ailments for which she's entitled. And she went into great detail at trial as to why she certified these patients. And keep in mind that a big part of her certifications was also the OASIS reports that were prepared by the home health agencies, many of which had fraudulent representations in them because they were trying to get her to certify. You know, if she were just on the take, this would have been so much easier. Why did she leave 4,100
Right,
claims?
but these are good jury arguments, though.
I know, but
Right.
But the point is this is why it's important to have a medical expert to counter and to say there's no decision on medical necessity here. And in the cases, we've cited a litany of cases from this court and others where medical experts were in fact put on when the issue of medical judgment was at issue, which is what is at issue here.
Yeah, keep going.
Okay. So in each of the cases where the courts...
But do save a little time for the sentencing loss.
Yes, I will try to do that, and I do have rebuttal, so, but I will definitely get to that. In the cases where the court has dispensed with an expert requirement, there are cases where they use words like pervasive or strong indicia of fraud. That's missing here. This was a very close case.
All three strong indicia of fraud missing, or a little debate on the third? She saw everyone, right?
She saw everyone.
She didn't falsify any charts.
She did not falsify any charts. She did not sign blank checks. She did not tell anybody to falsify information. She actually conducted the tests for which she billed Medicare. I mean, she thoroughly looked at everything. The only patient complaint was that she took too much time with them. I mean, this was not somebody who never saw the patients, never examined them. Situation. She had her treatment notes, her treatment plans. Most of these patients came back to her over and over again, so she had a lot of information. It just does not satisfy the court's dividing line in Martinez that cases that do not require patient or expert testimony typically involve a close inference, such as treating patients on specific dates and specific times for which the doctor could not have possibly rendered services. So the jury is hearing all this, well, so-and-so was walking around, so-and-so took the bus. There's no proof that she knew any of this anywhere. That's all circumstantial and inference, piled on inference. But going even beyond that, they are lay people that can't look at the whole host of considerations that go into determining whether a patient is in need of home health care.
They were able to do it as to one count, right? They did particularize and acquit her on one.
Because there was nothing there. I think Ms. Maddox pretty much flamed out on the stand. So that's a whole different ballgame. But as to the other patients, there's really nothing there. I mean, she certified. We have one expert telling, but she was also the defendant. So that put her in a terrible situation, having to defend herself and also be her own expert witness because there were no others allowed. The loss calculation, I do want to touch on that, is also unsupported because, and I'm going to focus on the extrapolation piece because you just can't get from here to there. And it's important because
what about as a threshold issue if I said, and the government suggests it's harmless anyway because Judge Ellison said, I'm going to give you a loss amount that would be as if I had affirmed every objection?
He still went above the mark that he would have gone to had he credited all of the objections. He still was at $9.5 million and 5 years. So though he would have had a lot more ability to vary. I mean, the understanding is that he probably would have liked to have given probation based on his comments, et cetera, and the people in the courtroom. But he didn't have that ability because they were seeking 25 years and $19 million. So to come down from that was so much. And I think it's really important because they proved two claims, if they proved them. And again, I'll leave that to the briefs. They proved two claims of fraud, yet she is getting attributed loss of $9.5 million based on 7,400 claims. And they never put on those files. They never audited those files, and they admitted.
Well, they put on the analyst. Are you saying there's Part B that amounts that shouldn't have been, or Part A, or both?
Both, because Part A did not have the 4,100 claims of the nurse.
Part B is pretty clear. She actually saw them, gave legitimate services. You've got to get an offset.
Right, but it included all the services, even if they came in later for a colonoscopy or something like that. That was thrown into the Part B mix.
Explain again what we do with Judge Ellison's statement that he would have imposed the very same sentence even if he'd granted your objections.
Again, I think that if those, it's difficult to reconcile. I mean, I think that those are statements made for the record, and I understand where he's coming from. He was trying to be careful here, and probably avoid a cross appeal, to be quite honest.
But he might have done it.
Well,
is restitution different than loss in our assessment here? Because she did get down to 60 months, but the restitution stayed at $9 million.
Right. He used an allocated loss of $9.5 million. which was at the lowest end where he could afford that sentence. I think restitution is the same thing. It's certainly what the government lost in theory versus what she recovered, because what she recovered, there's no disgorgement here. It would be very little. And so it focuses on restitution, if I'm understanding your question correctly.
I think you have, and you've saved rebuttal time. Sorry, our time. You've saved rebuttal time. Thank you.
Yes, Your Honor, thank you.
Mr. Noll?
Thank you, Your Honors, and may it please the Court. Andrew Noll on behalf of the United States. I'm happy to start with the expert testimony-related issue, given the arguments this morning, and I want to make two observations right up front about that. In response to your question, Judge Higginson, about but that it was raised at the Rule 29 proceedings, you won't find the word expert anywhere in the defense counsel's mid-trial Rule 29 argument or the post-trial briefing. This wasn't an issue that was formally raised to the district court about whether there's a sufficiency problem if there's no expert testimony with respect to the fraud. I would also emphasize that count one of the indictment—
But sufficiency is preserved.
Sufficiency is preserved, Your Honor, but
And we have dicta. Should we basically write out the dicta in Sanji and Martinez? Is it all just bluster when we say there may be a case that's technical enough that the government would have to have an expert?
So I don't think so, Your Honor. We're certainly not advocating any categorical rule that expert testimony is never required, but I think this court has been quite clear in Sanjar, Martinez, and the Mesquia's case most recently that there are a number of different evidentiary bases the jury can use to evaluate both direct and circumstantially the medical necessity of certain services. Before I get to that, though, I just want to emphasize on count one, which is the healthcare conspiracy, there were two manner and means that were charged with respect to that conspiracy, one of which is the certification of non-homebound individuals, but the other and equally important means is the soliciting and receipt of a kickback with relation to every individual. So with respect to the sufficiency counts, and I'm happy to talk about loss separately in a second, but with respect to the sufficiency counts, in terms of medical necessity, the jury really only necessarily had to assess the medical necessity of Martin and Miller in order to convict on counts 3 and 4. And then for the conspiracy count, at least find that Ms. Hamilton made an agreement knowingly and willfully to certify non-homebound individuals. The jury wasn't required to sort of quantify the extent to which individuals were or were not.
Well, focus on Martin and Miller. What's your best case that you can just put the patient on who would say, I didn't think I had cancer? And therefore, the doctor who made a diagnosis saying, well, you do, a jury could just decide that was a criminal false statement?
My best case, Your Honor, is the Sanjar case, where Judge Costa said quite directly that with medical necessity, the patient's experience is actually quite probative for the jury because they can provide an understanding and explanation of whether they did or did not have the condition. And I'd also emphasize that with homebound, the question of whether this person can leave the home faces a taxing ability to leave the home. And here the jury was able to see Mr. Miller and Ms. Martin walk around the courtroom, testify to their experiences at the time of the certifications. And it also emphasized that with respect to each of these individuals, Ms. Hamilton certified them 9 and 10 times repeatedly over a 20 to 24-month period. So the jury also had a track record of notwithstanding the patient's condition that they were testifying to, that Ms. Hamilton recertified them over and over again. And that was consistent with, I would say, the testimony of Hamilton's employees as well as the home health agency owners. Now we had,
But would you agree, just in the dialogue I had with opposing counsel, it is a closer case than most because she actually did do charts. I don't think you proved that any of those charts were falsified.
So we didn't claim that.
And she did sit down with every single one of these patients, right?
She did, Your Honor, but let me explain that I do think there are some, quote, red flag indicators here that this court has said are an additional evidence that the jury can look to kind of assess medical necessity. The first is, as I said, the testimony of the home health agency owners. So you had Stella DeRue, one of the owners, who testified that in her assessment, many of her patients were not homebound, and yet every single time her company paid the $60 fee, their patients were nevertheless certified. That was true of Ms. Chasm as well. Every time they paid the $60 fee, they were certified. You had Lori McMillan, who was the Medicare contractor who testified to the requirements, testified that it's a red flag indicator for an individual to be recertified over and over again for home health care because it's intended to be a short-term benefit. And again, with at least Miller and Martin, we had the specific testimony of 9 and 10 times, but there was additional evidence of individuals being recertified over and again every time a $60 fee was paid. The third thing I would say is with respect to Mr. Miller, we walked through specifically his intake forms with Ms. Hamilton, and I would just direct this court specifically to pages 3309 to 3311.
This is the Form 485?
No, these are the intakes that he filled out when he came to Ms. Hamilton, and in one of them he checked he was in good condition. On another one he said he didn't have any pain sitting or standing, so there were indicia on the face of his intake.
Back to the just rule of law question. What's the limiting principle? Can you just describe a case where the government would have to prove up medical necessity, not falsify medical necessity with an expert?
So I think, Your Honor, if there were a case where the medical issue was one that is not apparent.
You can't think of anyone that has been published by any court?
No, there's not. I'm not aware.
What about all the cases they cite? I think it's in the reply brief. You probably remember by footnote. I think it was footnote 6. There are probably a half dozen cases where it looks like expert testimony was offered by the government.
So, Your Honor, I think those are district court cases or out-of-circuit cases, is my understanding. I don't believe there's a circuit case that has said expert testimony is required. Okay. My understanding is in those cases, the government either affirmatively put in expert testimony because the medical issue was sufficiently technical that it may be difficult for a jury to understand, perhaps out of an abundance of caution, or a court made a fact-specific finding in that case. But I'm not aware of any.
So your answer would be the government proceeds at its peril if it doesn't, because she's the expert. She took the stand. They got a one-sided view, which was it was correct medical judgment. So the government took a risk by not.
So
is that sort of the way it is?
I don't think so, Your Honor, given, again, the Sanger, Martinez, and Ms. Kia's cases from this circuit that over and again state that there may be specific cases where expert testimony is required, but by and large, there's a number of different ways that a jury can assess medical necessity. And all I'm suggesting is in this case, where the question is whether individuals are homebound, that is something that is right within the jury's ken, particularly when the individual is in the courtroom walking around. And again, I would just reemphasize the kickback-related scheme here because I think that it was a critical, important part of the—
Yeah, but when you say that's critical, am I correct? If she actually saw them, she was entitled to the copay. So in a way, where's the kickback? Because she would have gotten that money anyway.
Your Honor, she was entitled to a copay again, for non-Medicaid eligible dual beneficiaries, but she was not entitled to have home health agencies, medical providers, pay her for that kickback, for that copay, in which case it becomes a kickback. And here we provided, I think, 6 or 7 different ways that the jury could find that this was, in fact, a kickback and not a copay. You had the testimony of the agency owners that they were paying the $60. You had the testimony that it was not varying across individuals, and we put in, or we referenced the defendant's Medicare remittances, which were in evidence, which showed that the copay amount varied considerably depending on the services provided, and $60 was not even a reasonable estimate of
what is your very best authority for the notion that a copay could still qualify as a kickback?
A copay?
That a copay could nonetheless qualify as a kickback. What is your best authority for that?
So I would refer this court to the Daly case in which it talked about whether the Form 485 can be a referral for purposes of the kickback statute. I don't know that this court was confronted of the question of whether payment of a copay rather than some other charge would be a kickback, but I think the best authority, Your Honor, is the anti-kickback statute, which is 42 U.S.C. section 1320A-7BB, which specifically states that any receipt of any remuneration for the soliciting or encouragement to provide health services is unlawful under the federal code. And so I don't think, McMillan testified at trial, for example, that she could think of no circumstances in which a payment from a home health agency to an individual, to a provider, would be lawful. Whether that's covered up as being called for the kickback or not, I think the problem is with the the source of the funds there. Now, I'd also emphasize we focused on rebutting the copay theory in part to show knowledge and willfulness, because the defense's theory in defense was that this was a copay. We wanted to, disprove that to the jury to make clear that she wasn't making an honest mistake. But I think even if it is a copay, if the home health agency is paying that in our view is still a violation of the anti-kickback statute. Just briefly to talk about the Ezra Care case that opposing counsel mentioned from the 11th Circuit. It's a Ketam case. On page 8 of its slip opinion in Ms. Kia's last week, this court held that or distinguished that case, which was fully briefed by both sides in that opinion in that case, and said that the Ms. Kia's Ezra Care does not establish that expert testimony is required in a criminal Medicare case, in part because in that case there was no evidence except for after the fact expert testimony about the medical necessity of the claims. And here, as I mentioned, we had both the specific testimony of 3 beneficiaries that were put on in evidence, as well as the testimony of 3 home health agency owners, Hamilton's employees, and the like. I'm happy to chat briefly about the sentencing guidelines calculation and the loss amount, if that would be helpful to the court. The district court did not reversibly err in calculating the guidelines range, and that is where the loss amount factored in here. As we noted in our brief, we don't think restitution has been preserved. There's no argument on appeal as to the restitution. So really the question is whether the court...
Well, that's a little hard for me to accept. I mean, when you object to loss, you're objecting to restitution almost inherently, right? Because it's the actual damage directly caused by the crime offensive conviction.
So you're not, Your Honor, in part because the guidelines loss calculation is the greater of intended or actual loss, right. And there's a separate set of sort of legal parameters in terms of that.
The government asked for a restitution of 17 or 19 million.
19 million, Your Honor, yes.
And then the court said 9.5.
That's correct.
Am I correct? Nowhere any analysis of that by the district judge.
So the district judge said that it was reducing the amount of loss and restitution to take care of any argument that the amount was not fully accurate. And I think that I understand the court to have been saying it was taking an overly conservative estimate of the loss to make sure
I can see that as a 3553 no loss problem, no guideline prison problem. But I don't see how that protects a restitution order.
So, Your Honor, the government respectfully hasn't cross-appealed the restitution order, and we're the victim with respect to the restitution. So, if anything, if it's error, it was in Hamilton's favor, because our view is that it was 19 million and quite higher than what the district court set as the actual loss amount.
She's got to pay back $9.5 million.
Yes, that's correct, Your Honor. And that's...
Can you tell me now that the record confirms that no Part B amounts were in that? As to, let me get this straight, you can probably help me here, where Hamilton actually saw and gave services unrelated to the kickback certification.
So I want to clarify the record about what Part B aspects were included in the loss amount, Your Honor. It's not correct to say that there were services provided that had no connection to the kickback scheme. Because
I'm just asking, were there any amounts for when she saw them? So a legitimate service was given under that Matthews test, the 2-part test. Because I don't think your suggestion in the brief is right, that just because the fraud gave them the opportunity to come in the door means you wouldn't offset her credit.
So I do think that's correct, Your Honor.
Okay, what's your best case for that?
So I think, again, I go back to the kickback statute, which says that Medicare does not pay for services provided or received by way of a kickback. And again, what we did is we took all the Part B claims but looked for specific instances using the G codes, which show when an individual was certified or recertified for home health care. And then using those G codes, we identified the specific day that certain individuals came to Hamilton's office. And we included all Part B services on those days.
So your position legally is if they did come and they got services that they needed, that would still be included, even though this isn't a pervasive fraud case?
So Your Honor is correct. We did argue pervasive fraud below. The district court didn't make a finding as to that, so we're not.
Right, and your analyst was able to segregate anyway, so it doesn't look like it doesn't look like a pervasive fraud case. You put a witness on who was segregating amounts.
Well, again, they were segregating the specific dates where there were certifications and recertifications. We didn't enter into evidence at trial as specific, here's the G-code amounts.
But you agree, the district court didn't base it on pervasive fraud.
I agree, yes, for purposes of this appeal.
So do you also agree, therefore, we've got to ask just the two-part test? Were legitimate services given? And would the government pay but for the crime?
So I agree Your Honor has to ask whether there was a prima facie case made of these services were fraudulent. With respect to an offset, where the question under Matthews is whether a defendant can get credit for legitimate service provided, this court has made clear that that's the defendant's burden to come forward if the prima facie case is made. And I would suggest to this court that as to the Part B, our prima facie case was made out in two ways. First, the use of the G-codes to isolate services provided on the specific days that individuals were certified or recertified.
Even if the services were needed, a colonoscopy or whatever.
Well, the second thing I want to say is there is evidence that those services were not medically necessary. So you had Roberts, which was one of...
Is there a finding by the district court as to that?
I don't think there was a specific finding as to the medical necessity of the other services provided in addition. Now, I would also ask this court to look closely at the Part B records of the three named beneficiaries, which are in the record at pages 6151 to 59 of the record. And there you'll see that, by and large, the Part B amounts are driven by the certification and the associated office visits.
Largely, so probably encompassed within his huge variance downward.
I think that's right.
What about the Part A, though?
So the Part A, Your Honor, what we did is it's not correct to say that we based the loss calculation on every patient that Ms. Hamilton saw. What we did is we took only instances in which the Form 485 was located in Hamilton's office, either in paper records or on her electronic.
But isn't that possible that that included a patient that a nurse practitioner saw instead of Ms. Hamilton?
I don't think so, Your Honor, for two reasons. Okay. First, I'd emphasize with respect to these alleged 4,100 claims, I'd encourage the court to look at a record 8740 to 66, 8740, which is the exhibit that Hamilton put in that was created through Mr. Ali, providing this list of claims. It's only 1,486 individuals. I think there was a transcription error in the actual testimony by Mr. Ali about the number of claims. If you look at the exhibit, there's only 1,400 claims, not 4,100 claims. But I think the important point is we limited, again, the Form 485 to those that were found in Hamilton's office. And there was repeated testimony from her employees, from the home health agency owners, and from Ms. Hamilton herself, that every Form 485 from her office was only released if a $60 payment was made. And so I think we can assume, that weeded out half, about 15 million claims that were on her Part A billing, but not included in her loss amount, because we focused only on the Form 485s in her office. And we had consistent testimony that a $60 fee was paid for her to release Form 485s. And so I think our view is we showed by a preponderance that if a form was found in her office, it wasn't an instance in which a nurse practitioner saw her and there was no payment. I can't splice it any further than that, and of course, the district court varied quite substantially from the loss amount and didn't make a effort to go through line by line. But I think we've met.
So no evidence was taken at sentencing. Judge Ellison just said, "I heard it all at the trial." And basically that supports the way the PSR did it? Is that basically how it happened?
That's correct. The PSR went through the trial testimony and evidence with respect to the government's contractor, and there was also an FBI agent who testified. And based on that evidence and the body of evidence, the PSR...
Jenkins. Is that Jenkins?
That's Jenkins, Kevin Jenkins. Yes, that's correct. The last thing I would say, Your Honor, is with respect to the harmlessness. So again, we had Judge Ellison saying that he was reducing Hamilton's sentence to be as if he had granted every one of her objections. And it's not correct to say that there was any indication the district court wanted to give a probationary sentence. I don't have the specific site, but in the sentencing transcript, in its allocution, the court said it doesn't think this is a case in which a non-incarcerative sentence is appropriate. So I would just emphasize that even if there's any error in the loss calculation in terms of setting the guidelines range, that was error in Hamilton's favor, and there's no indication the district court would have sentenced her to anything other than the 60-month incarcerative sentence it chose. I'm happy to address any other questions the court might have, but the government would otherwise rest on its brief and simply request that this court affirm the judgment of the district court.
Thank you, counsel.
Thank you.
Ms. Greer.
Before we get started, I think opposing counsel just said that the district judge specifically said it was not a non-incarceration case. Do you disagree with that? Because I thought you were saying that he wanted probation.
I'm going on the understanding I had. The judge really struggled with this decision. And
You don't have anything to cite then?
I don't have a cite to that, just from the people who were in the courtroom, and maybe that was out of line, but I do think it's relevant to what was in his mind when he did that. But at the end of the day,
Just to be clear, opposing counsel is saying, for the record, the district judge said this is not a probation case.
for the record, that is what the judge said. But he didn't have any ability to vary because of the numbers they were putting in front of him. And the $9.5 million in the 5 years does not really take care of the objection. The objection was that these loss numbers were so elevated through this extrapolation process with no support for it, that if you took those out, you would be looking at what was in the indictment, which was $275,000 from Medicare, and then another maybe $375 from the copays that she earned from the office visits, but that's the number that he should have been looking at. And the $9.5 million obviously takes into account all of those other claims. To the point about the what was included in the Part A, if you look at the government's witnesses charts, Mr. Jenkins prepared a chart that was introduced into evidence. I don't have the exhibit number, but it's ROA 6161. There were 7,461 claims. It included, and the 485, she had the 485s for the nurse practitioner visits because that was part of her certification. And she didn't charge a copay, but she did review them and she did certify those claims. So those were all tossed into the mix as well. That's where they got the $19 million. And to be clear, Mr. Jenkins was not a statistical expert. All he did was crunch some numbers. And he started with what was on file with Medicare.
Go ahead, keep going. But well, okay, simple, just procedural question. Once the PSR accepted that and you did object,
We did.
then does the burden shift to you at sentencing to try to disprove those calculations?
To disprove everything, I mean, I still think at a fundamental level, there has to be sufficient evidence with something to support it, not just this fictionalized account of what could be. And at the end of the day, I think that sufficiency of the evidence challenge cuts across all of it. And we did put on evidence. There was plenty of evidence that some of those people should not have been included. Start with Winder Maddox, who was the the patient for whom Dr. Hamilton was acquitted. She shouldn't have been in that number. No question, right? She was acquitted. She was. And also just the nurse practitioner's claims. There were so many. There were forgeries. There was evidence of all of that she put on that should have questioned whether all of them should have gone in. And at some point, the government should have to prove its case. She couldn't have possibly disproved, what would it be, 7,459 claims?
Right.
I mean, that's too much of a burden to ask of a defendant.
Do you have an immediate recollection as to whether there was a specific objection to the restitution amount as distinct from the loss amount? You heard him.
Go back and look at that, Your Honor.
Yeah,
I haven't
we
thought about
can.
it that way, to be honest.
Yeah.
But I know that we did object to the extrapolation on both grounds. I want to touch briefly on the point about back on the fraud expert testimony. Oh, and Your Honor was correct in remembering that it was footnote 6 of our reply brief that contains all the cases from this and the other circuits. And there are 3 circuit court level decisions as well as some district court cases. But the point is the government knows how to put on an expert when it needs to. And I don't think it's too much of a burden to ask the government to disprove medical necessity.
Why isn't that an issue of litigation strategy as opposed to legal mandate?
Well, it could be litigation strategy, but at the end of the day, you have to carry your burden.
The cases you're citing, at the end of the day, the government chose to do it. It's not courts forcing them to do it, is it?
I think they chose to do it because they needed that evidence. Because once you challenge a doctor's certification decision.
Right, but if the government doesn't present evidence, then go ahead. Sorry, you have 30 seconds left.
Well, I want to briefly touch on how Medicare looks at this issue, and we cited the Medicare manual. This is the manual on integrity and how they review these judgments of the doctor. The clinical review looks at the synthesis of all the submitted medical information. It looks at the diagnostic findings, the progress notes, the medication, the nursing notes, the OASIS, everything. And the credentials of the reviewer have to ensure that a licensed medical professional will perform this medical review. So Medicare itself, when it audits, you know, when they get the red flags like we've talked about in the cases, it happened to Dr. Hamilton with respect to, you know, initial office visits. When they get those red flags that are generated by an algorithm, they have a review process that is very specific. And in that review process, they require...
You just want to, your red light came on. I know you're very focused. You want to wrap up the thought?
Sure. They require that a licensed medical professional of equal integrity, in other words, another physician with her experience and credentials, is the only person that can challenge an actual finding of medical necessity.
Thank you, counsel. Case is presented. We appreciate that assistance. Call the second case of the day, 21-50419, Carlos.